agent's duty to a buyer was forever changed in 1984 with the case of Easton versus Stassberger. The ruling in Easton stated that the agent had an affirmative duty to conduct a, quote, reasonable, competent, and diligent inspection of residential real property listed for sale and to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. However, the Easton's court ruling was vague and raised many questions regarding interpretation. What did competent and diligent entail regarding the scope of the inspection? Based on Easton's competent and diligent language, it could be argued that the agent was required to essentially be a home inspector, which is not an expertise possessed by most, if any, agents, and was certainly not a part of or related to their training. The California legislature sought to clarify the Easton ruling with California Civil Code Section 2079. Pursuant to Section 2079, agents have a duty to prospective buyers to conduct a reasonable, competent, and diligent visual inspection of the real property offered for sale and to disclose to the prospective buyer any material facts affecting the value or desirability of the property. The visual inspection language of Section 2079 provided the much-needed clarification to the Easton ruling. With Section 2079, an agent's inspection would be strictly limited to what they could see. How does an agent fulfill their duty under California Civil Section 2079? Most agents turn to the California Association of Realtors for guidance. CAR has crafted the Agent Visual Inspection Disclosure Form. This form provides a systematic process for an agent to conduct their visual inspection. However, the form provides little advice on how items should or should not be noted in the report. It's important to understand that Section 2079 requires a, quote, visual inspection only. As the CAR form states, there is no obligation to look under carpets, in crawl spaces, attics, or even move furniture. Also, don't use the avid as an opportunity to further market the property. You should not make statements such as stunning views from the family room. Again, this does little to show you have conducted the required inspection and may infer that the agent is trying to hide something. The agent should also not make assertions outside their area of expertise. Agents must understand, unless they have the appropriate license or training, they should not make statements in the avid properly attributed to another professional, such as a plumber, electrician, pest control professional, or similar. For example, agents must not make any statements such as evidence of rodent droppings, possible infestation. Observing droppings is one thing, but determining that they are rodent droppings and then declaring an infestation goes beyond the scope of the agent's duty. With the previous statement, the agent is holding themselves out as an expert by identifying the droppings and then declaring an infestation. Unless an agent is a pest control professional, they have no expertise on which to base this statement. The observations placed in the avid are important. The avid is the written record of the agent fulfilling their duty pursuant to California Code Section 2079. As such, it's imperative that the agent pay special attention to what they observe and how it is noted in the avid.